Good morning, everyone. My name is John Giardinelli. I am Association Counsel. I am also with the law firm of Tyler and Birch. And as I promised last time, we're going to go through some issues relating to protecting your commission and what the hearing officers at the board will look for in order to determine who would prevail in a dispute over who is entitled to the commission. I'm going to narrow it down to one particular type of dispute, and that has to do with commissions that arise out of the multiple listing service. As you all know, the multiple listing service has several rules. One says that you must make a unilateral offer of compensation whenever you place a listing into the multiple listing service. Obviously, there's no rule as to how much or how little that can be because of antitrust implications. And the issue of offering compensation and those rules are under attack in the courts. But for right now, that's the rule. And then the rule goes on to state, and the commission that is offered in the multiple listing service is earned by the agent or broker who procure the buyer for that particular property. Sometimes disputes arise because more than one office has worked with a buyer, and one agent may think they're the ones who procured the buyer, and another agent may disagree and believe that they procured the buyer. And of course, if the parties can't agree, either through mediation or otherwise, then they end up going to the Association of Realtors, where the respondent is a member or where the property is located. Most of the time, if there's a dispute internally at the same office, that's handled by the contract, and the broker will step in and resolve that. Under the multiple listing service rules, there is a duty to arbitrate all disputes arising out of commission offers in the multiple listing service. There's also a code of ethics rule that governs realtor conduct. That is Article 17 of the Code of Ethics. If there is a dispute, the burden will be on the claimant. So if I'm bringing a claim against another agent and I believe I'm the one that is entitled to the commission, it will be my burden to prove to the hearing panel by what is called a preponderance of the evidence, which is defined in, you can Google it, it's not that complicated. It's not an onerous burden like beyond a reasonable doubt or anything like that. It simply means more likely than not. And that the claimant must bear that burden of proof. Couple of things that you can do to avoid these kinds of issues is always ask a prospective buyer whether they're working with another broker or another agent. Because if they say yes, the hearing panel at this association will insist that you call that other agent and try and figure out what's going on. Do they agree that they were the procuring cause? Is there a battle? Can you try and resolve it with a referral fee or something like that? If you discover that another agent has been involved in the transaction, find out why the client left. It may be because the agent wasn't responding accurately or was not acting competently, or it simply may be because they feel they can get a better deal with you. And again, those issues are going to be important if the case goes to a hearing. You don't want to get in a situation where you do all the work to close the transaction only to find out that someone else procured the buyer and is going to be entitled to the commission. Wherever you can, and I think, frankly, if I were in charge of things, I would insist that everyone have a buyer-broker representation agreement. And I've been told that there may be some changes to the ones that are in existence now, but I don't know that for sure, and I don't know when that will happen. If it were up to me and a number of other people, there would be mandatory use of these forms. It would, but frankly, it would help you in making your case. accompany your client to open houses. Don't simply send them off, because then some other agent who is sitting the open house is going to sign them up, or feel that they did the work to introduce the property and all that. You're just going to buy yourself some trouble. Stay in close contact with your clients. Make sure that your clients are aware that you are concerned about them. I understand that in today's incredibly dynamic market, it's probably more important than ever that you stay in touch with your clients, that you make sure that they understand that everything that you're doing for them, that you're not just simply sitting around, that you're looking at multiple options for them, because again, it's very important that they understand that you are working on their behalf, so they don't drift off to another agent who might service them better. Keep a registry of all your prospective clients. Keep a record if you're sitting in open house. Make sure that you can establish the connection that you've had with these people, and then have sign-in sheets as well. Okay, so as far as, and there's lots of other tips, and so you're in a situation where you've been working with a buyer. You feel that the buyer was able to purchase a house, and again, this isn't about showing property. This is about actually purchasing a house where a commission has been earned and is due to someone, or has been paid to someone. It could have been an agent who double-ended. It could be another broker from another office. So now you're stuck. You've tried to settle, you couldn't. Now you have to go to arbitration at the board. And what are those hearing officers going to look like? Well, they're given all kinds of stuff to analyze the case. They're going to read your complaint. They're going to read the respondent's response, if the respondent files a response, and then they're going to listen to the testimony, and they're going to use what are called procuring cause guidelines to help them analyze the case. I want to emphasize that the procuring cause guidelines are not a scorecard. One issue is not more valuable than another. And there are 25 guidelines. And I'm going to tell you where you can go get more information when I close this out. But I'm just going to go over some of the more common guidelines that are alleged at these hearings. One of the guidelines is, or one of the sections of the guidelines is the connection of the transaction by the brokers involved. So who introduced the buyer to the property? Is that even significant in today's marketplace with videos and everything else? But it is an issue as to who introduced the buyer to the property. Did the broker for the buyer who allegedly earned the commission even ever show the property to this buyer, or did they simply write up an offer? And if they did work with this buyer, how much information was provided? A lot of you provide an awful lot of information about neighborhoods and all the other kinds of issues that buyers are interested in. And so that issue could be important. And then an issue that really, if you don't have a written offer that you presented, going to be very difficult, not impossible, but difficult. And that is, did the broker write an offer, and was the offer that was written and either rejected or not responded to similar to the offer that was ultimately accepted? That sometimes can be because the buyer left the buyer broker, went to the listing broker, who used the offer that had been presented previously and simply rewrote it and maybe changed some financial feature to offer a kickback or something like that. So that issue is going to be one of the more important issues. Did you write up an offer, and was it similar to the offer that was ultimately accepted? And then, of course, how long of a period of time lapsed? Again, was the significant information provided by whom in terms of property the property itself. And then the second category is the issue of buyer's choice. Did the buyer, for example, leave a listing broker who they were working with in order to get individual representation because they did not want dual agency, they wanted their own separate representation? Very, very significant. Were they dissatisfied legitimately with your services? Were you not responsive to their needs? Were you late in getting information? Did you not provide an offer quickly and respond quickly to listing agent inquiries and questions? All of those kinds of things. In other words, your competency literally comes into question. And again, there are features within that for the hearing officers to try and determine whether it was simply a personality conflict or whether there was a legitimate question of your competency, and or not necessarily competency in the sense of malpractice, but maybe just the way you treated these people. You didn't respond to phone calls, you were condescending in the way you talked to them, and so forth. And then the most important category is broker by conduct. Again, if you don't ask, and it turns out that the buyers have been working with another agent, that is not going to go well for you. Here's the deal, because I actually trained your hearing officers very recently and got them to tell me what they were looking for, and it was very clear. Number one, you better ask. You better ask the buyer, the prospective buyer, have you been working with another agent? If they respond affirmatively, or it's pretty clear, or you have an indication because maybe another offer came in from another agent, you better call that other agent and find out what their position is, whether they believe they're in a procuring cause situation that maybe you can get resolved early, maybe you can offer a referral fee, maybe you guys can work it out to avoid having the hearing officers make the decision of who gets the compensation for you. You can agree to close the deal and maybe you go to mediation. There's lots of ways you can work it out. But the bottom line is, if you take up the representation of a buyer and it turns out that the other agent did more or sufficient in the eyes of the hearing officers to justify them getting the commission, you will have done all the work, exposed yourself to all that potential liability, and you conceivably will end up getting nothing. Another issue, just in summarizing, there's about 5 or 6 guidelines that can go under the category of what conversation did you have with your client? Did you tell them how to act at an open house? Don't tell them you're working with me or something like that. Did you tell them to be loyal? Were you playing games with the other brokers so that you could double end the deal? What's going on? And again, it's broken down into a couple of separate categories that go into the conduct of the broker. And again, remember who you're arguing in front of. These are highly professional, well-experienced real estate agents and brokers who are hearing your case, have been trained. For the most part, the hearing officers served on the grievance committee where they analyzed ethics cases for a while. All of them have been through hearings before, sometimes ethics hearings, sometimes arbitration hearings. No one ever sits on a panel without first having sat as an observer or an alternate. And so they're pretty experienced. They understand that what you do is a profession. They don't like game playing. And so your conduct is going to be an important issue, not necessarily a deciding issue, although it could be, but it's going to certainly be important if you were playing games. And then lastly, in the area of conduct, is, were you the listing agent who lured a buyer away from an agent by offering a financial incentive, simply to pull that buyer away from another agent? And if so, again, that could be an issue. And then lastly, as I mentioned before, is there any documentation? Do you have an agency disclosure form, which you better have if you've written a prior offer? Do you have a buyer broker representation agreement, things of that nature? So again, a lot of issues. I have just simply covered the surface in what could be in a 2 or 3 hour program. But what I want you to understand is there are many ways you can protect yourself. A couple of things that I would urge you to do is Google the word CAR, or California Association of Realtors, procuring cause, and that will bring up a whole number of resources, papers that have been written on the subject, more detailed documentation. So if you feel that you have a dispute with another agent or broker relating to the question of your commission, you have a lot of resources available to you, and you can take a look, make a decision, because there is a filing fee. If you decide to go forward with the hearing, there is a filing fee. I believe it's $500. You will get it back as part of an award if you're successful, but you don't want to throw good money after bad. And so you want to be able to analyze, talk to a lawyer if necessary. You're entitled to have a lawyer at the hearing, or you can represent yourself. And of course, the broker has to participate in some fashion, because these commissions are awarded to the broker. Act ethically. For example, a standard Article 1 Standard Practice 1-7 says you have a duty to advise the broker representing the buyer that all offers have been presented to the sellers in an objective way. So act ethically, be attentive to your clients, document your files carefully in terms of your contacts with people, and hopefully you can avoid these commission disputes. In closing, I'll tell you about a case we had about 2-3 years ago. Property was listed with a 2.5% offer of compensation to the cooperating broker. The property was a $45 million house. One agent did a whole bunch of work, and there was then a dispute between the buyer and that agent. So the buyer went to another agent. That agent closed the deal. There was an arbitration. The parties could not agree or settle. The lawyers were very adversarial and hostile. And at the end of the day, one buyer's agent received the entire $900,000 commission, and the other buyer's agent, who actually closed the transaction, got nothing. So I urge you to take these cases very, very seriously, whether it's a $5,000 commission, a $50,000 commission, or a much larger commission, as in many transactions today. You're going to work very hard to close these deals. You want to make sure you get paid at the end of the day. So this is John Giardinelli signing off. Till next time with John's Rants, and hopefully you'll find this information helpful. If you do have a commission dispute, you can go to CAR, get a lot of information. It's a good training tool for those brokers who want to help their agents protect their commissions. And again, make sure that you understand when a buyer who has worked with other agents comes to you, what you're dealing with. So until next time, good luck, and we'll talk to you soon. Thank you very much. Bye-bye.